Today I'm going to host a session of about 40 minutes in duration, and I'm going to be in conversation with two practitioners in the field of coronial practice. Firstly, David Claxton, who regularly appears in Inquests, where Article 2 is engaged, and Aimee Riese, similarly experienced and was junior counsel to the judge-led inquest into the death of Ellie Butler back in 2016. That's my mum ringing me, I suspect. We're going to be picking their brains on a number of topics. Firstly, the impact of COVID from exposure in the workplace, a review of some of the recent developments in the conduct of Article 2 compliant inquests, and more generally, the limits on the scope of an inquest following the decision in Hambleton, a consideration of the standard of proof that applies in those very unfortunate cases of suspected suicide following the decision in Morn, and various issues in between. I'm pleased to say, as you can all see, that I'm joined by the Chief Coroner for England and Wales, and of course the Recorder of London, His Honour Judge Mark Lucraft, QC. I'm extremely grateful to him for giving up his valuable time to be with us this afternoon, because I know he's already been to the Guildhall and is due to zip off to Manchester this afternoon. I'm not going to take any questions, I'm afraid, because of the pressure of time that we have of 40 minutes or so. But if you'd like to use the Q&A functionality to forward a query, then we'll try and deal with them in slower time by email after the webinar has concluded. So kicking off, if I could turn to you, please, Judge. You took up your post as Chief Coroner in 2016, and I think are due to relinquish your duties as and when they appoint your successor in the not too distant future. And of course, you've led the inquests into the terror attacks in London Bridge and Borough Market. And your role as Chief Coroner includes responsibility for providing support, leadership and guidance for coroners, as well as setting national standards, including review of the inquest rules. Can I ask you to perhaps give us some reflections and insights that you've developed from your tenure?
Tom, yes, I mean, it's been a fascinating 4-year period. I mean, if you had asked me when I took the job on, if I knew precisely what the list of tasks that I would be doing was, I think I probably wouldn't have been able to tell you quite what it concerned. And to some extent, events rather took over. So in 2017, there were the 2 attacks you've mentioned on Westminster Bridge and indeed on London Bridge, and the inquests that I then covered. But of course, there was also the Manchester Arena attack and the terrible fire at Grenfell Tower. And part of the Chief Coroner's role is to have a national role in relation to mass fatalities. And one of the very first issues that I had to consider in October when I took over was the training programme for all coroners that was going to start the following March. And I decided that we should train all coroners rather more extensively in how to deal with mass fatality events. Little did I realise that when I made that decision in November of 2016, quite what was going to happen in the years that followed. But training at the bar when I was in chambers and training now is something which I've always been very interested in. And one of the concerns that's often raised, particularly about coroners, is the lack of a consistent approach to cases which may, to the outside world, look broadly similar. And so this was an opportunity to develop training on the issue of how to cope with a mass fatality event. We modelled the training around the Shoreham air crash, which people will recall and has been the subject also for criminal trial. But effectively, we had mocked up a mass fatality event, and we took it through stage by stage, stopping the incident at various stages to effectively say to the coroners present on the course, this has happened, what would you do next? And so it was an opportunity for me to address an area of concern, how we deal with mass fatality events, but also to look at how best we might tackle consistency of approach going forward. And that, the last 4 years, I've tried to develop that form of training. In recent training, we've taken a mock inquest and again stopped the process at various stages, really just to address judgecraft, use of language, how you control advocates, and again with an idea not of stipulating what coroners must do, but just trying to give better guidance on how to provide more consistent approaches, but also hopefully more consistent outcomes for members of the public who are involved in those situations. But it's a multi-headed job in a way, Tom. I mean, I've ended up being a litigant in some fairly important litigation. The case of Morn that you've mentioned, which is we're currently awaiting a decision from the Supreme Court, where I intervened in the early parts of that litigation, just to ensure that all of the arguments were put before the court in respect of the competing issues, not just on suicide, but also on unlawful killing. I've also played a key role in terms of updating parts of the guidance which my predecessor, Peter Thornton, had put in place. I mean, he, you will recall, was responsible for setting up, in large part, the Office of Chief Coroner, and spent 4 years starting from zero, building up to a fantastic battery of really good bits of guidance. But my approach was to try and expand that guidance, make it publicly available, with the hope that advocates would use it as much as coroners, so that we would have a common platform in which decisions could be made. It is only guidance, it is no more than that, but I hope again that's been a useful thing to have done, not just for coroners, as I say, but also for practitioners who are appearing at inquests. But I think that the third thing that I would think is quite important is that I felt very much that coroners are regarded by other branches of the judiciary, or were, I should say, as being a rather poor cousin. And I was very keen to make sure that other judges realise that actually coroners are judges just as much as they are, and they should feel part of a wider judicial family. And that is beginning to bear fruit. And I hope the coroners who've seen that develop will see that that's a good trend, a good positive trend. They are often dealing with very difficult cases, often on their own. And so to feel that they're part of a wider judicial family, I think is very important.
Yeah, thanks for that. Those are all really interesting points. And if you don't mind, after or during picking the brains of our two practitioners, I might ask you to join in their discussion. But you mentioned guidance, and Aimee, what I'd like to do is turn to you first, and I'm just going to share my screen with the attendees. Hopefully they can see that now. And I'm going to ask you please to address one of the first topics I think you can deal with, and that is the issue of COVID-19 deaths and possible exposure in the workplace. And picking up on what the judge has just said, I think we've got some useful guidance on this very issue.
Yes, the Chief Coroner has issued guidance on this issue. It's guidance number 37, and it was amended on the 1st of July. And this guidance sets out the circumstances in which a COVID-related death might be the subject of an inquest. And as the Chief Coroner has said, it is guidance, it's not policy, but it's an expression of the law as it currently stands, and is indeed very useful for practitioners.
So it's designed, is it not, to assist coroners to continue, as the judge has remarked, to exercise their judicial decisions independently. But can you help us by considering the circumstances in which a coroner's duty under Section 1(2) of the Act to conduct an investigation into a COVID-19 death might arise?
In general terms, a death must be investigated and must usually be the subject of an inquest if the coroner has reason to suspect that the deceased died an unnatural death. So a death from COVID-19, a naturally occurring disease, will not in itself be an unnatural death, and will not in itself need to be referred to a coroner. However, there may be some circumstances where a death from COVID would be reported to a coroner. Specifically, if there was a reason to suspect some human failure contributed to the death, then there may be a requirement to open an inquest. And in addition, the regulation cited on the slide provides that there must be a report to the coroner if the medical practitioner who completes the medical certificate of cause of death suspects that that person's death was due to an injury or disease attributable to any employment held during the person's lifetime. So deaths that occur in the workplace setting may need to be investigated.
Okay, so what's very clear is this is all about the fact-sensitive matrix of a particular death, but perhaps you can provide us with some examples which illustrate when the duty to investigate in these particular circumstances might be triggered.
Well, this guidance sets out 4 main examples where a coroner may need to open an investigation. The first is if there was a reason to suspect some human failure contributed to the person being infected with the virus. The second is if an investigation were opened, whether any failures of precautions in a particular workplace caused the deceased to contract the virus and so contributed to the death. The third is whether some failure of clinical care contributed to the death. And the fourth is, of course, if this person died in state detention. So in the COVID-19 scenario, the obvious example perhaps of a death that might need an investigation is for an NHS or other frontline emergency worker who died of COVID after workplace exposure, where there was reason to suspect some human failing contributed to that death. And that failing perhaps might be, for example, the lack of adequate provision of PPE from the employer. But coroners are likely to scrutinise these issues very carefully and be wary of straying into the realms of addressing concerns about high-level public policy.
Okay, so I can see that a straightened view of the purpose of an inquest, so answering the 4 statutory questions, most notably how the particular deceased person came by his or her death, might not find much room for consideration of high-level government or public policy, however attractive and interesting that might be to us all. But I think you can help us develop this by reference to authority, which you've cited on this slide.
Yes, well, the guidance itself draws attention to this body of case law that's held that a coroner's inquest is not usually the right forum for addressing concerns about high-level government policy. But the key case here is cited in the guidance, and the full citation is on the slide. And in this case, Lord Phillips observed that an inquest could properly consider whether a soldier had died because a flak jacket had been pierced by a sniper's bullet, but the inquest would not be the tribunal for investigating whether more effective flak jackets could and should have been supplied by the Ministry of Defence. So this means that the overarching policy questions of whether the government provided the NHS frontline workers with adequate PPE, in this example, are unlikely to be the subject of an inquest. However, there's no reason to prevent the investigation of the adequacy of the PPE in a particular hospital, in a particular individual case, where some human failing might be identified as contributing to the death of the person. And indeed, the guidance says there's no hard or fast rules about the scope of the inquiry. So if you're a practitioner representing a bereaved family who's concerned with the policies that were in place at the place of work of the deceased, then you should be ready to make submissions that emphasize the particular nature of the individual case, rather than the broader public policy questions, in order that those procedures or systems that were in place at the time, which should properly form part of the subject matter of an inquest, are properly brought to the attention of the coroner.
Yeah, that's good advice, particularly where everything's fact sensitive, and it's an investigation into the particular death, meaning this is a sort of topic that perhaps would be best explored at the outset in a pre-inquest review. But there are some potential real practical problems with this too, are there not?
Yes, the coroner always has to pursue a fact-sensitive inquiry and gather all the information that he or she might need. And the guidance quite rightly anticipates that during the period that we are in at the moment of an ongoing pandemic, it might be difficult for the coroner to do so. For example, it might be difficult for the coroner to approach certain hospitals due to pressures on the NHS at the moment. So as always, coroners will need to balance the need for further investigation with the interest that the family may have in a prompt and timely investigation. And the coroner will have to consider the views of the family and all the factors in the individual case before deciding how to proceed.
So looking towards outcomes, as it were, and although I recognise ancillary to the primary purpose of investigation, might reports on action to prevent future death, or PFDs as they're shortened to, be important in this process?
Yes, and the guidance on reports to prevent future deaths is currently contained in guidance number 5. And looking briefly firstly at how these reports work, where a concern is identified by the coroner then has a duty to make a report. And a concern is that there is risk to life in present or future circumstances. The aim of a PFD is to raise the coroner's concerns to say that the coroner thinks that action should be taken. The role of the coroner is not to tell an organisation or person what that action specifically should be, but they then send that report to all the relevant persons, and those persons are then invited to respond to the report in a time frame. So this PFD can be a powerful tool for preventing deaths by raising concerns. If the overarching aim of the coronial system is not to attribute civil or criminal liability in a particular case, but in fact to prevent the loss of future life, then this has the potential to be a tool for powerful systemic change. But having said that, there are quite a few criticisms of the lack of central coordination of these reports, and coroners aren't able to easily follow up or enforce the recommendations in any way. Perhaps doing that is not really a role for a coroner in any event, but if no one is scrutinising whether a change has been made by an organisation, then the risk of future deaths may remain. It's also hard to identify thematic patterns or systemic problems from individual reports. For example, if a particular failing were to occur in multiple hospital settings, considered by multiple separate inquests, it may be that the system might not pick up the systemic nature of a particular problem. So it's interesting to think about whether this system can fulfill the aims that it sets out to achieve.
I think, Judge, you've got some interesting new news on this topic.
Yes, I mean, prevention of future death reports, Tom, has been something which has been a concern of mine for a while. And again, going back to this issue of consistency. And so one of the pieces of guidance that Aimee mentioned, guidance number 5, has gone through a period of review by me, and it's going to be reissued in the coming days. What I'm going to publish alongside it are some sample PFD reports. Again, before we currently publish them on my part of the judiciary website, we have to go through them just to make sure that we're not making public private details. So, for example, someone's telephone number or email address that shouldn't be made public. And so the idea is to give clearer guidance to coroners who are writing these reports about how the report should be formatted. I'm hoping that they will produce a more consistent way in which reports are prepared and sent to my office. And also there will be a more consistent approach to when the reports are actually the duty of the coroner to make a report. You've mentioned already that, of course, a coroner can't, as the law currently stands, has no real teeth to follow up on the points that are made, and whether that would be something for the coroner to do in any event is, I suspect, something that we would all have different views about. But I know that there are some thoughts that, for example, Dame Eilish Angelini, in her highly regarded report about deaths in custody, did make a recommendation that there should be some national office of Article 2 compliance. And it may well be that in due course, Parliament thinks that actually the role of chasing up or following on from recommendations made by coroners is something that, if there were such an office, should take on that responsibility too. To say that the guidance will be sent out and made public within the next few days, or certainly within the next couple of weeks.
Thanks very much. That's a really interesting new development. Aimee, just switching back to you briefly and looking at things on a more macro level, there's plainly a discussion to be had about the shape of any future public inquiry into the handling of the pandemic. How could that impact on your everyday inquest that perhaps traverses the same sort of ground?
Yes, it will be interesting to see if there is a public inquiry into the government's handling of the pandemic. The Act provides that a coroner can suspend an inquest when asked to by the Lord Chancellor on the basis that the cause of death is likely to be investigated by an inquiry. So it may well be the case where there is an inquest ongoing, where the issues relate to the adequacy of the provision of PPE. If a public inquiry were to examine those issues more broadly, then that inquest may well be suspended.
I see. What I'm going to do now is turn on, if I may, to a slightly different issue, although allied to it, which is the issue of systemic failings in the area of healthcare, particularly the decision in Iroko, where, as the judge has recently pointed out, he was a litigant in that, I think.
Well, in fact, Tom, no, I was part of the court that gave the judgment in Iroko.
Yes, you're right. Thank you for correcting me about that. But it dealt really with the obligation to hold an Article 2 compliant inquest where a death occurs in the context of medical care. So turning to you, David, and whilst my cursor's just gone to sleep to bring up the slide that you can speak to, perhaps you kick us off whilst I sort that out and tell us about what the case was about and what the grounds of challenge were.
Yeah, so in Iroko, in due course, the slide will give you the full name. The citation was a case in which judgment was given in July of this year, and it provides a link to these issues in that it was a case which arose from a death in the context of medical care, and where the grounds of judicial review were these. One, the decision that the procedural obligations of an Article 2 inquest did not apply. Two, the failure to explore the issue of neglect. And three, omitting to make a prevention of future deaths report. To set the scene briefly, the claimant was a relative of the deceased. She had presented at an urgent care centre with symptoms of vomiting and abdominal pain. A working diagnosis of gastroenteritis was made and other symptoms, and she was given advice as to what she should do in the event that other symptoms presented. She later attended hospital where a doctor referred her to A&E. After various inquiries and a period in hospital, the deceased was discharged, again with a working diagnosis of gastroenteritis. Crucially, before that discharge, it was recorded in the medical notes that DNR has not been agreed. The evening following her discharge, she went into cardiac arrest at home and an ambulance crew attended, followed by an advanced medical practitioner. Efforts were made at resuscitation, but no signs of life returned, save for a weak adrenaline-induced pulse. The deceased was in this condition when she was taken to A&E. The treating doctor performed tests, the results of which indicated significant mortality. He left her with a medical team in order to speak to her family, and on his return, and following instructions that had been given, after a further cardiac arrest, the team were performing CPR. After considering the circumstances, it was decided that CPR should be stopped, and Mrs. Iroko was declared dead. At some point following the first discharge from hospital, a DNR notice was added to the medical records. In fact, Mrs. Iroko had had an intestinal blockage, which was likely connected with scarring that had resulted from historical lower abdominal surgery.
So that's the factual matrix, but what were the actual claimant's grounds of challenge?
So ground one was the decision not to hold an Article 2 inquest. The Divisional Court considered the legislation and authorities in relation to Article 2 inquests, holding that a death in a healthcare setting will not lead to this type of inquest, save in exceptional circumstances. The positive obligations on the state are regulatory, that is, taking necessary measures to ensure implementation, including supervision and enforcement. The issue had been considered recently in Maguire, which had in turn applied the human rights jurisprudence of the Strasbourg court in Fernandez. The exceptional circumstances in that case were identified as 1, a specific situation where an individual patient's life is knowingly put in danger by the denial of access to life-saving emergency treatment. It does not, it was said, extend to circumstances where a patient is considered to have received deficient, incorrect, or delayed treatment. And 2, where a systemic or structural dysfunction in hospital services results in a patient being deprived of access to life-saving treatment and the authorities knew or ought to have known about the risk and failed to undertake the necessary measures to prevent the risk from materializing. In Iroko, that Fernandez test was described as strict and as requiring the following. 1, the acts or omissions of healthcare providers must go beyond mere error or negligence insofar as the healthcare professionals, in breach of their professional obligations, deny a patient emergency medical treatment, despite being fully aware that the person's life is at risk if that treatment is not given. 2, the dysfunction must be objectively and genuinely identifiable, systemic or structural in nature in order to be attributable to the state authorities. 3, there must be a link between the dysfunction complained of and the harm which the patient sustained. And finally, number 4, the dysfunction in issue must have resulted from the failure of the state to meet its obligations to provide a regulatory framework. It was held that the facts did not disclose the sort of systemic factors that would have warranted an Article 2 inquest.
So that's a pretty high threshold test, essentially. But I think this case also had something interesting to say about the application of the Jameson test, where neglect was also being explored.
Yes, it was effectively a restatement of established principle, but the basis upon which the applicant contended that a finding of neglect should have been open was the fact of past abdominal surgery, which the treating physicians were not fully aware of, in which could have been detected on an abdominal X-ray and corrected through surgery. This ground was rejected. The court emphasised the definition of neglect propounded in Jameson. Neglect in this context requires more than even gross negligence. It means, and I quote, a gross failure to provide basic medical attention, although a failure to provide medical attention for a dependent person whose position is such as to show that he obviously needs it may amount to neglect. And the ultimate decision was that this particular case, again, and I quote, clearly fell outside the narrow definition of neglect.
Yeah, so again, a pretty straitened test and use of words such as narrow. But how would you say, given the high hurdles that the divisional court was being throwing up, how would you say that that plays into the scope of an inquest into a death arising from COVID-19?
Well, we've thought about this, and it seems to us that there are some obvious examples where there'd be an interplay between the scope of inquests and issues connected to COVID-19. And they are, first, where someone contracts that illness in the course of their employment in a healthcare setting or while receiving treatment as a patient, and where the availability or adequacy of personal protective equipment was an issue. The PPE question could apply at both a local level, that's to say that the relevant employer failed to make adequate provision, or at a national level, the potential failure of national government in relation to macro procurement. And as to which of those is an issue, it may have a bearing on whether it's within or out with the scope of an inquest. The second, the rationing of access to ventilation, coupled with the adequacy of strategic reserves of ventilation capacity. And third, the availability of testing in the early stages of the pandemic, particularly as that applied to the discharge of hospital patients into care homes.
So if all of these issues do come into play in any putative case in the future, this appears to potentially have quite an impact for medical professionals. I mean, how do you see their status as interested parties either growing or diminishing?
I think it's difficult to judge whether the status of individual medical professions in inquests will be affected, but doctors are routinely afforded interested person status, particularly GPs, in the context of, for example, of a family member who is contending for a finding of neglect, in circumstances where a patient, for example, is on the radar of the relevant health body and has missed appointments or failed to engage and is not followed up on by a named GP at a given practice, for example. And if the test is applied properly, the narrow straightens test, as you called it, it's highly unlikely that a finding of neglect could be reached in such circumstances. So it raises the question of whether there is an issue wherein medical professionals are too often drawn into the inquest process, but where a finding of neglect, which is the only conclusion that would be available even theoretically, is highly unlikely to be capable of being made out on the given set of facts.
All right, and finally, in this case of Iroko, it might be interesting to know what it said, if anything, about PFDs.
Well, so far as PFDs are concerned, that issue more or less fell away as a result of the court's decision on issues 1 and 2, effectively because those had been disposed of negatively so far as the application was concerned. The question of whether or not a prevention of future deaths report ought to have been made didn't arise.
Nice. And the judge has kindly given us an update on how the guidance is going to be updated in the next few days. So let's turn to another topic now, which is our old friend, the scope of an inquest, David, and the scope in more general terms, and dealing with the test in Hambleton. I mean, a great deal of time is spent ensuring an inquest is kept within a proper scope, but perhaps you could spin us through the principles that emerged from Hambleton by firstly giving us a précis of what that case was about.
Well, that case arose out of the reopening of the 1974 inquest into the Birmingham bombings. And the scope of the inquests as a general topic was addressed. The court emphasised the inquisitorial process and the fact that there are not, in a conventional sense of the word, parties to an inquest. The duty on a coroner, it was said, is to investigate the circumstances of a death by reference to the 4 questions. It was observed that it is common for the scope of an inquest to be addressed as part of a pre-inquest review. It was said that a decision on the scope represents a coroner's view about what is necessary, desirable and proportionate by way of an investigation to enable the statutory functions to be discharged. These are not hard-edged questions. The decision on scope, just as the decision on which witnesses to call, the breadth of the evidence to be adduced, is for the coroner. The court went on to add that the scope of an inquest is not determined by looking at the broad circumstances of what occurred and requiring all matters touching those circumstances to be explained. What was referred to as the perpetrator issue was considered, the issue being that it had been contended that the scope of the inquest should include examining the identity of the individuals who had planted the bombs. The prospect created a tension as to the resolution of questions of civil and criminal liability, which are expressly outside of the ambit of an inquest. In relation to that, it was said that it is difficult to criticise the coroner, still less to stigmatise as unlawful, a decision to refuse to explore a distinct question which the jury is prohibited by statute from answering. Before reaching this conclusion, the court had observed that the coroner had been correct to hold that his exclusion of the perpetrator issue did not mean that it would never be appropriate to hear evidence that spoke of who was responsible for homicide. It was said to be not a black and white issue. And the court concluded the judgment by holding that the decision of the coroner to exclude the perpetrator issue when determining the scope of the inquest was correct and not unlawful in a public law sense. The question that the judgment leaves open is, what are the circumstances in which touching on the perpetrator issue would be appropriate?
And I think you've cited on your slide here the really interesting case of GS, which concerned, of course, Miss Sturgis and the Salisbury poisonings, and an attempt in that case to examine the involvement of a state actor in those deaths. I'm not sure we've got enough time to go through the ins and outs of that case, but I think, Judge, that's coming back, isn't it, before a coroner, perhaps a judge-led inquiry in due course.
Yes, I mean, I think, Tom, looking at what the judgment says, it's likely to be the case where I will be having to appoint or seek the appointment of a judge to deal with that inquest, ultimately. And obviously, part of that might just be to deal with the proper determination of scope, because you'll appreciate that to some extent a coroner can only make a determination about scope by seeing the material that's there, and if they can't look at that material, it makes it slightly difficult to make that determination.
Yeah, good point. Well, that segues in nicely, Aimee, with the issue of disclosure, because of course a case like Hamilton and others that the judge has dealt with, notably the terror attacks, raise massive disclosure management exercises. But on a more basic level, for some attendees perhaps, and not for others, but for some, perhaps you could take us on a quick tiptoe through the legal toolbox in this regard.
Part 3 of the coroner's rules sets out how all relevant evidence should be disclosed to the family in advance. So practitioners will want to ensure that coroners use their full powers under paragraph 1 of Schedule 5 of the Act to compel those with relevant material to hand them over for onward disclosure then to the IPs.
And what standards of candour, for example, are being applied under Schedule 5 in this exercise?
Well, in terms of the disclosure obligations of a public body in an inquest, there's no statutory duty of candour. However, the Ministry of Justice has recently published the government's protocol that sets out the principles it expects to guide the behaviour of government legal department lawyers and those they instruct at inquests. And this includes the suggestion to approach the inquest with openness and honesty, including supporting the disclosure of all relevant and disclosable information to the coroner. And the Parliamentary Justice Committee has recently also called for evidence into the effectiveness of the coroner's service. And the charity Justice has made a very interesting submission. One of their key recommendations is for a statutory duty of candour, subject, of course, to the privilege against self-incrimination. And this is because there is a perception from some bereaved families of institutional defensiveness. So perhaps a statutory disclosure regime for inquests could help this situation. But going back to the practical considerations for practitioners around disclosure obligations, for practitioners, if you're representing a public body, then there are very limited circumstances in which full and frank disclosure would not be appropriate. If representing another interested party, it's always important to write to the coroner and to the other parties to request all disclosure, because practitioners should not assume that the coroner has requested all the information that might be relevant. They might not be aware of all of the issues at the beginning. So it might be useful to make specific disclosure requests for policy documents, previous investigations, training documents, serious case reviews, disciplinary proceedings, all these types of material which might be specific to the issues in the case and would need to be disclosed.
Well, I can see that those are the sorts of issues that are going to appear on agendas in pre-inquest reviews. But it's all well and good when it comes to public bodies and duties of candour, but perhaps, and this is just a personal comment, I venture to suggest that statutory duties of candour for private entities might also be in the better public interest if, after all, this is about preventing the preventable. But of course, some material that a public body holds might just be too sensitive to disclose, because of sensitivities is to do with public interest immunity. How's that squared with the open justice principle in the coronial system?
Well, normally one basis upon which disclosure can be refused is where information is covered by public interest immunity. And for a public interest immunity, a PII application to succeed, there must be a real risk of serious harm to an important public interest. And even if that hurdle is reached, the court must disclose the information unless the public interest in non-disclosure outweighs the public interest in the open administration of justice. And this open justice principle applies in an inquest. There is a large body of authority emphasising its importance. PII is a last resort. But if closed material does need to be considered, this might be a reason perhaps for a public inquiry to be necessary instead. However, pragmatic approaches can often be taken, for example, appropriate redaction or appropriate gisting to ensure that the relevant information is still disclosed. And the arrangements that were made in the London Bridge inquest were an example of this. Perhaps that's something that the Chief Coroner could comment on.
Yeah, well, it would be interesting, Judge, because you've obviously conducted some judge-led inquests where some extremely sensitive underlying material might have been in play, but you've managed to conduct open inquests to the satisfaction of the parties. How did you achieve that?
Well, Tom, it's a very difficult balancing act. I think we managed to achieve a fairly good balance in both Westminster Bridge and London Bridge Borough Market inquests. But I'm sure if you were to ask some people, they may have felt that we didn't perhaps ask all the questions that could have been asked. But I was particularly keen that we should make or can keep those inquests as inquests rather than having to become public inquiries, if at all possible. And we had the unprecedented position in London Bridge Borough Market of a senior official from the security services giving evidence for 2 days in public. The individual was screened from participants, but they were asked questions on behalf of the families. Extensive questions or directly proper questions, and if the individual felt that they couldn't answer in line with the decisions that had been made about what should be disclosed, then they indicated that. But certainly in my conversations with the families, particularly those individuals from overseas who were sadly killed in those attacks, certainly they welcomed the fact that we were doing this. And certainly one of the families from France made clear to me that had this event taken place in France, they did not have the same degree of comfort that actually somebody from the security services in France would necessarily have been made available for them to ask the questions that were asked on their behalf of the senior individual from our security services. So, Tom, it ends up in all of these cases being a very fine balancing decision. And as the participants, those attending this webinar will know, in Manchester Arena, that has become a public inquiry. Obviously, I can't go into all the ins and outs as to why that might have happened, but I can assure you that it's not an easy exercise. It takes a lot of time to go through and actually working out what one can do, but also having an eye on the limits as to what can properly be done within a coroner's inquest is very important.
Well, thank you, Judge. It is obviously a very difficult exercise. Aimee, I was going to invite you to say something about Ketcher and Mitchell, which is about privilege, but time's pressing on. So I'm going to skip that, but anybody who's watching this webinar, it's an interesting decision about the scope of privilege in a coronial setting. And move on, if you don't mind, please, to a standalone topic, David, which is about the standard of proof in these very unfortunate cases that sometimes arise of suspected suicides. And the slide that we can move on to is Morn, this interesting case of Morn, which is the judges said at the outset, was considered by the Supreme Court in February, I think, this year, so that the speeches in the judgment are due very soon. What was this case about, firstly?
So this is a Court of Appeal case that we're in a position to speak about. But as you say, it has gone before the Supreme Court. There were two issues. One, whether the standard of proof in cases where suicide is under consideration is the civil or criminal standard. And two, whether the standard of proof is affected by whether the conclusion is to be given in short form or narrative. The simple facts were that the deceased was found hanging in a prison cell. The questions were whether he had hanged himself, whether in doing so he had intended to take his own life, and whether his death was caused or contributed to by a failure to protect his life on the part of the prison authorities. And in terms of what it decided, the court concluded that the appropriate standard of proof in respect of suicide was the civil standard, irrespective of the form in which a conclusion is rendered. And the court also considered unlawful killing. The arguments in favour of the civil standard in relation to conclusions of unlawful killing were considered and described as attractive and cogent, but nonetheless rejected. The reasons given included the observation that, whilst inquests are not criminal proceedings, unlawful killing, in contrast with suicide and all other conclusions open to an inquest, connotes a crime. Thus, unlawful killing can properly be considered to have its own special status, as it were, a conclusion at an inquest. And after listing additional reasons for the finding that the correct standard was the criminal standard, Lord Justice Davies observed that in indicating these considerations, I should not be taken as necessarily agreeing myself that this ought to be the outcome. I can see a very powerful case for saying that the standard of proof applicable to unlawful killing cases in inquests should observation. He added this: it is unfortunate that so important a matter as the standard of proof applicable in inquests, extending not only to unlawful killing but also to suicide, has thus far been left, in effect, to a piecemeal decision-making process by the courts and by practice guidance. Given the availability of the relevant rulemaking power in Section 45 of the 2009 Act, it would surely be greatly preferable and would put matters beyond all debate if the desired position was now expressly articulated within the coroner's rules themselves.
Okay, so Judge, I think the standard practice has been really to adopt a civil standard, but I imagine you're going to await the outcome of the speeches in Morn in the Supreme Court before you take any action.
I am, Tom, as I mentioned, I intervened in this litigation not with any agenda. Make it very clear, I didn't, in the course of any of the submissions, argue for one point or the other. I just felt it was a hugely important case for the court to consider the arguments both in respect of suicide and in respect of unlawful killing. And Jonathan Hoff, who was the silk representing me, put those arguments very well and very clearly before both the divisional court and indeed before the Court of Appeal. Sorry, the Court of Appeal and the Supreme Court. And we will need to await their speeches, see what they say, whether it needs any clearer guidance from me in respect of suicide will very much depend on whether they stay with the Court of Appeal's decision. But of course, if they were to determine that in relation to unlawful killing, that the lower civil standard applies, then that would obviously need for me to make fairly quick action to give guidance to coroners in respect of how they should approach cases involving potential conclusions of unlawful killing.
Thanks very much. Well, that is, I think, as they say, all we've got time for today. We've tiptoed in and around and over some complex ground. I hope we've provided some interesting insights. I know the judge has. I'm enormously grateful to him and to our two practitioner contributors. I'm going to conclude this webinar in a moment. When I do so, I won't be able even to see the participants. And so I shall be in touch with them very soon and with you, Judge, very soon. But thank you very much for taking the time to be with us. Drawing things to that conclusion, the only thing remains for me to say is that there is a further webinar on the 14th of October this month on the topic of international cooperation, in particular production orders, that's going to be presented by Shane Caleri, Queen's Counsel, and another team of practitioner contributors. So if you're interested in that topic, I'd encourage you to sign up and listen to what they've got to say. So thanks very much indeed, and I hope you will have a very good afternoon.